and I am actually coming to you live from my home studio. The virtual background reminds me of what it was once like to work in an office, unlike my colleagues, who I will introduce very shortly, who have sensibly got a background reflecting more where they are and should be in Victoria at the current moment. I'd like to welcome everybody to today's webinar and reiterate that our webinar today is directed towards home care providers. Within that, the audience that we're directing towards are those at the senior levels of the organisations, which includes the CEO, CFOs, COOs, GMs, General Counsel, Compliance and Risk Officers. But I'm sure that we will have something for everyone during the course of the webinar today. Perhaps if we can move to the next slide. Just a bit of housekeeping to kick off the webinar so that everybody is understanding of what they can expect today. Certainly all attendees will be on mute and your cameras will be turned off for the entire webinar. So you have the misfortune of only looking at those heads that are currently on the screen at the moment for it. For those of you experiencing any technical issues, we've got live tech support who are ready to assist. Now, just to specify, we've got two functions that are going to be very useful for the webinar today. I know we've had a little bit of confusion in the past, but we have the opportunity for you to ask questions during the webinar so that we can answer them. And answering those will take place either via myself or one of the panelists during or after their webinar presentation or at the end. Or through one of our lawyers who is working behind the background to provide the answers to the questions. So that's the Q&A function. There's also a separate chat function, and we typically reserve the chat function for you to perhaps ask for specific assistance with any technical issues, or if you've got any helpful comments regarding the technical aspects of the webinar. And indeed, you may have a comment generally to make, but separate out, we'll be focusing on the Q&A function for questions related to the content today. Following the webinar, there will be a post-webinar survey link which will be sent to you. We certainly value your feedback and would ask that you fill that out and give us some feedback. We'll have a QR code which links to our feedback survey attached to the presentation, which we'll also send to you at the end of the webinar. So we'll send out the presentation slides. There'll be a QR slide at the end of that. And if you click on that, fill out the feedback form, that allows us to provide better content for you into the future. And finally, this webinar is being recorded. And so we're going to be held to account for anything that is said or not said today in the future. But more importantly, if you miss anything or you wish to share it, then you'll be able to at the end of the webinar when we get it up live on our website. So with that, one of the things that I'd like to reiterate with our webinar is that the information we are providing today is by way of general commentary only and shouldn't be regarded as legal advice. With your questions, again, we can only answer them in a general sort of a way. And so therefore, perhaps if your questions are asked in a general sort of a way, we can provide a very general sort of an answer that generally should be helpful. If, however, you've got any specific questions or we think that you require more detailed advice, then we'd seek to do that separately, or you can contact any one of us directly so that we can provide advice that's tailored to your unique situation. So with that, what I'd like to do is to just introduce our panellists for today and give you a bit of a brief overview of what they're going to be talking about. So Anita Courtney will be first. Anita is, you're familiar with Anita, I'm sure. She's a principal in our aged care team with a focus on assisting the home care sector. She specialises in helping home care providers comply with their legal responsibilities. And certainly it's becoming more and more of a pronounced activity as we see more compliance activity from the Commission in relation to the home care sector. And this is, of course, increasingly so, and a trend that's been continuing for many years. Anita will be addressing you on a few of the main compliance issues that we're coming across, particularly in relation to pricing, fees and home care expenditure, and providing some strategies that you can implement to mitigate your risk in these areas. When Anita's finished speaking, we'll then move across to Solomon Miller. Solomon represents our corporate commercial area. He's a principal in that space, and specialises in providing advice for a range of aged care, home care and health clients in the areas of mergers and amalgamations, governance, privacy and compliance matters. He has been doing this for over 18 years, which of course means that he started when he was 1 year old, judging by how he looks. But today he will explain how you can get your supporting documentation right to mitigate risks. He'll also talk about our recently launched Easy English Guide and provide comments on insurance and indemnity trends. Last, but by no means least, is Anthony Massaro. Anthony is a principal in our Workplace Relations Employment and Safety team. He has been providing advice to home care providers on workplace issues for over 17 years, which means that was probably about 6 months old when he started. In this webinar, Anthony is going to discuss a number of employment and safety related issues for the home care sector. I said Anthony was last but by no means least, and of course I misstated the position because working behind the scenes is the true brains of the Res team, Abby Burns. Abby is going to be working hard to provide answers to some of the questions. She is a senior associate in our workplace relations team and will be assisting with answering those questions for you. So perhaps with that, I can conclude my aspect of this and then, oh no, I can't. I've got one more thing to do, which is to give you an overview of what we're going to be talking about today, which you can see I've already trotted through the first couple of dot points. But as I said, Anita, we'll be looking at current compliance issues in home care, which are set out there. We'll then move to looking at the contracting and suppliers issues, workplace issues. Then we'll move to a live Q&A. So those questions that you've asked that we haven't answered during the running of it or during the general presentation, we'll seek to get to. And our aim is to get through all of the questions that you pose. And given that we've got about nearly 300 people who said they'll join this webinar, then we should have a number of questions to get through, but we're going to try and do that. And then we'll wrap up at the end with some key takeaways. And of course, what would the webinar be without us then telling you how we can actually help you further? So we'll do that. So without any more, I'm going to turn my mic onto mute and hand it over to Anita.
Thank you, Victor, and welcome everyone. So as Victor said, I wanted to talk through a few of the sort of key issues that we've been working on at the moment with clients. So the first one I thought I'd start with is the transition to the home care pricing transparency rules that occurred sort of this 1 July. As you all know, providers had until this July to transition all their pre-1 July 2019 clients onto the new pricing rules. So to recap what these really are in summary, firstly, you have to publish your fees in your pricing schedule and include a copy of that on the My Aged Care website, and also include a copy in every client's agreement. And if a client isn't paying the fees that are in your schedule, you have to include a reason why that is in the client agreement. And the second major change is that you must not charge a separate fee for business costs. In other words, what used to be administration fees. Rather, these types of overheads have to now be built into your service costs and your care management costs. So I think the industry adapted fairly well to the new pricing rules, particularly for the clients that signed up since last July. And the industry then had a year to get all their previous clients onto the new regime. In other words, for clients who commenced prior to 1 July 2019, you had to basically go back and renegotiate with those clients to put the pricing schedule into their agreement and to charge them in accordance with that pricing schedule. Now, the problem is, and this is something that is actually being looked at by the regulators and LASER and AXA at the moment, but you have to, under the legislation, obtain clients' consent before you make any changes to their client agreement or the way you charge them. That's all fine if clients will agree, but issues arise. What happens if a client refuses to provide consent? I know of some providers who have clients who are just simply refusing to engage with them over this issue, typically as leverage to get something they want. For example, they might want to do a home extension, or they might want to buy another iPad when you think that they really don't require that. And unfortunately, with those sorts of consumers, you're in between a bit of a rock and a hard place, because you need them to sign a new agreement as of 1 July. And if they haven't already, you're actually already potentially in breach. And at the same time, how do you get them to give consent? So, some providers are taking the approach that so long as we take reasonable steps to get clients to agree to the new rules, that's all we can do. After all, clients do have the right to choose and That's very much a part of the consumer-directed care framework. Unfortunately, though, the legislation doesn't actually make this exception. True, I don't think a provider is going to get into trouble just because a client hasn't signed a copy of an agreement with the pricing schedule included. Where I do think the risks lie, though, is if you keep charging clients an administration fee, particularly if it's higher than your package management fee. Unless you can demonstrate that you're not using your administration fee to pay for business costs, then prima facie you're in breach of the pricing rules. Now, if you can say we don't use the administration fee for business costs, then you might be okay. But if your administration fee is higher than your package management fee that all the other clients are being charged, I'm not sure that that will be a very convincing argument. So it's a really difficult position. For example, you might have had a package admin fee of 15%. Now clients are paying a package management fee of 10%. How will you prove that that extra 5% isn't in fact going to overheads that it shouldn't be? So really the only way of really mitigating a risk here is to do whatever you can to get consent from the clients. Or if they refuse to do that, ensure you can justify that you're not using your administration fee for business costs. Importantly though, say you ultimately have to reduce the admin fee down to whatever your current package management fee because the client just won't agree, and you can't sort of demonstrate that you're not using the 15% for business costs, you can't then go and increase the service cost to offset that loss, because you have to obtain consent to make changes to clients' fees, as I'm going to talk a little bit more about in the next section. So unfortunately, right now, I think the legislation puts providers between a rock and a hard place when it comes to this. I do understand that the regulators will, apply some discretion in how they're enforcing this. If you've documented that you've done what you can and you've really tried to get consent and a client is just withholding it for whatever reason, I think it's very unlikely you're going to get into trouble. But are you safe? No, because the legislation is pretty clear that you can't charge a fee for business costs. So you do have to be quite careful with this issue. So just to the next slide, please. So on a sort of similar but related issue, I want to talk now about how you go about increasing your fees or changing your fee structure. It's quite common in the industry when providers want to change their fees that they write to their clients saying, here's our new fee structure, we're going to implement this from 1 July. And please contact us if you have any questions. And it's a sort of like it or leave it approach. If you want to change providers, go ahead. I'm not surprised this is common because it's so ubiquitous when we deal with all sorts of, commercial providers. That's how electricity companies operate, it's how telcos operate, it's how our gyms operate. So we're all used to this sort of model. How unfortunately, it is a problem in aged care to do it that way. The starting point in aged care is that you can only make changes to clients' fees or their agreements if you have the client's agreement or consent and you've adequately consulted with that client. So simply writing a letter which says, like it or leave it, here's our new fee structure, doesn't actually meet those requirements. If the client doesn't actually consent and actively consent, I should say, you can't put up their fees and you also can't just terminate their agreement because that would breach security of tenure. I do hear providers sometimes say, well, what about implied consent? And I agree, I think that there should be scope for that. However, I know from experience that the Commission really doesn't hold much, they won't accept this as a valid argument. So the risks are that if you move ahead in changing fees without consent and that it ends up in a complaint with the Commission, they may not only find you non-compliant, but they might actually require you to refund fees, not only to that client, but to all of the clients in that position. So it sounds silly, but this is even the case with the COVID supplement. Ultimately, it's up to a client whether they will agree to allow you to charge a fee to collect that supplement. Just writing a letter saying we're going to charge the COVID supplement effective from X date is not really going to cut it. You really do need to actively get the client's consent to make those sort of changes. Next slide, please. So in terms of what you can do to sort of mitigate this as an issue, the first thing, if you do need to go through a consent process to make changes, well, the best sort of way to do that at the moment, particularly when you may be limited in terms of having face-to-face contact with clients, is to write to clients, tell them what changes you want to make, and then speak to them, then get them to sign something to agree to those changes. That way you've ticked off on the consent and you've ticked off on showing that you've adequately consulted. However, if you want to avoid going through this every year, the best way is to have something in your client agreement that they sign upfront, which enables you to increase fees. So, for example, you might say, we're going to increase fees by CPI once a year, and that's what's in the standard Russell Kennedy agreements. I know some providers like to keep this quite flexible by saying something like, we can increase our fees by giving you 28 days notice. And that gives you a lot of discretion and ability to move your fees around. The problem with that is, though, it's too broad. It actually, and the Commission will not accept that as a basis for just making whatever changes you like. So if you rely on that sort of clause, in effect, you still need to go through that consultation process. So having something that's a bit more specific is better. Now, another perhaps more controversial way of dealing with this issue is to actually sign clients up for a 1-year term. And then when you want to change your fees, you give them your new contract. This is something that I don't think the regulators are going to be a big fan of, excuse me, because it really flies in the face of security of tenure. However, the legislation does in fact allow it. In other words, you can sign clients up for a limited term contract. At the end of that contract, you go back to the drawing board and you can renegotiate what your fees are. So that is another strategy that hasn't been employed to date. And as I said, I don't think OPAM or the Commission are going to really like that sort of approach, but I think it is permitted by the legislation and may get around this issue. And the only thing I'll say just before moving on from this is, if there's anyone in the room who's thinking, if there's anyone attending who's thinking, oops, I just did the letter approach, what can I do now? You can go back and retrospectively get consent. It's not ideal, but it's better late than never. So if you have gone down that path of raising your fees just following a letter and you think, I need to fix that, there are ways to do that. And we're helping a few providers with that at the moment. Next slide, please. Okay, so the third thing I talk about just is about whether charging the income tested care fee is mandatory, because we're having a few matters that have gone to the Commission and the Commission sort of telling providers off effectively for not charging and collecting the ITF. It is often said that it is mandatory to charge the income tested fee, and that's certainly the regulator's position. However, we've looked at this very closely and there actually isn't anything in the law that says that. The legislation makes no distinction between the basic daily fee and the income tested fee. However, whether or not it's mandatory under the Act isn't really that relevant, because there are risks if you don't charge it. So the first is, the regulators make it very clear that if someone needs that level of package, that's the level of service you need to provide if they want it. You can't force a client to take on services they don't want, obviously, and many clients have unspent funds. But if you had a client not paying the ITF and you said, well, we're going to reduce your services, and particularly if there were services they needed, I think that you could be at risk there of being found to be non-compliant. There are also risks when it comes to refunding unspent amounts at the end of the package. It's been suggested by a couple of providers to me that if a client has spent all of the subsidy amount, but they haven't paid the ITF, that the provider should in fact refund the Commonwealth to reflect the consumer's portion of the fees that they should have paid. And that might actually mean the provider's dipping into their own pocket, which seems highly unfair. I'm not sure I agree with that interpretation of the rules on refunds, but I don't really know where the regulators stand on that one. And it's possible that they might take that approach. So it is important for that reason to charge the ITF. Next slide, please. So these are sort of some tips, I think, for managing the issues around the income tested care fee. The first thing is you need to discuss it with clients on commencement, and that all sounds very obvious, but make clients aware that it is a fee they may be required to pay if they have that income. And on a related point, do put it in their client agreement, even if you don't have their assessment. I see a lot of agreements that have TBA or TBC when it comes to fees that we don't know what are the right amount are. It's my preference, and it's allowed, that you put the maximum amount in until proven otherwise. You can always refund fees if it turns out you shouldn't have charged them. But the risk, if you don't put it in there and you don't charge it, and then you find out you should have charged it, you've got to then chase that debt. So then, if the client doesn't pay, you really should take action. So make sure at minimum you're sending letters, you're sending invoices, and you're sending letters, and you're having discussions, and you document them. Because if a matter does go to the Complaints Commission, and what we see sometimes, I should say, is it's a client will not pay their ITF and they'll transfer their package across to another provider, and then it's the other provider who might make a complaint to the Commission. So that's often how these things might come out. And the Commission, when they're looking at this, they'll want to see that you actually took steps to collect the ITF from the client, and that you really need to document them well. The other thing, you might not need to actually look at suspending or reducing services, although, as I mentioned above, that is a bit risky because of that notion that you have to deliver services to the full value of the package. Finally, terminate. If under the legislation, you are entitled to terminate a client agreement if they don't pay their fees, and you may need to do that ultimately if they continue to refuse to pay the income tested fee. One thing I'll just say on termination, because some people get a little confused about this, you are not required to find them a new home care provider. Very different to residential care, where you've got to find them a new home to go to. There's no such requirement in home care, so you can just terminate. It's always best to give them, a good amount of warning before you go down that path, from a, general perspective and just from a relationship perspective. But you are absolutely entitled to terminate if they don't pay the ITF, and it's probably the cleanest way to deal with this issue before you end up with a $60,000 debt. The other thing you might look at, and this isn't very popular in home care, but debt collection. So it has been suggested by the Commission that providers should go sort of to that level of actually suing the client for that money. Obviously not a very popular one, but whether it's or not, you should actually look at that for extreme cases. It's something you definitely should consider. So that's all on that issue. Just to the next slide, please. Okay, so the final issue I just wanted to talk a bit about is home care expenditure requests, and really what is included and what is excluded from home care funds expenditure. So there is a renewed focus on this at the moment. The Commission is looking at matters that go to the complaints division of the Commission, and then going to compliance to look at whether or not the home care provider is allowing their clients to spend money on things they shouldn't. The rules about what you can and cannot allow consumers to use their package for are in the quality of care principles. So it's section 13 and part 3, and I know you all don't probably like looking at legislation as much as I do, but it is worth having a look at it, because that's where the basic rules are. We hear a lot of talk about what is and isn't allowed, but if you want to find the actual rules, that's where they are. So the legislation hasn't changed for many years, but the interpretation by the regulators as to what is and isn't allowed has changed a lot. And that's where we're seeing a lot more activity by them at the moment. They're very much scrutinising this issue. So one of the new manual that came out in March this year, it expands on what the Commission's view of what you can and can't use package funds for, what you can and can't use the package funds for. However, according to the manual, the Commission will direct providers to refund packages if they've allowed package funds to be spent on things they shouldn't. And that's a new principle they've come out with, and I'm not sure where they've taken that from, but it does give you an idea of the consequences if you particularly systemically, allow clients to use things for package funds for items that Commission doesn't like. So just next slide, please. So you do need to know the rules in terms of home care expenditure. And really, I break it down into things that are allowed, and they're listed in the principles, and then things that are clearly excluded. And you probably all know about them. That's things like gambling, Medicare funded items, home care fees, and all of those things. So do be aware of those lists. But also, I think this is the hardest category. It's what I call the items that are in the grey zone. So these are things that are not clearly on either list. So they're not allowed, they're not allowed, and they're somewhere in between. The legislation says you can use package funds to pay for an item in the grey zone if it's required to support the consumer to live at home. So those are the key words that you've got to bear in mind when you're looking at an item. So these are the sort of items that we've been asked about when we're asked to advise on this issue. And as you'll see there, for example, something like internet. Is it required to support the consumer to live at home? We know that you're not allowed to use package funds for utilities, but internet isn't listed there. And you might say, well, the internet helps the person stay connected. And you might even deliver care via sort of online forums like this at the moment. So you could argue that perhaps some of the internet costs are required to support the person to live at home, but it'd be struggle to justify the entire internet bill being paid for using package funds. It's my understanding the department has previously taken the view that you can use the package funds to pay for internet installation, but not ongoing bills. Whether or not that remains the case during this COVID period, I'm not sure. But it just shows the kind of difficulties you might have when you're looking at these grey zone items. So funeral costs and insurance, I know I've had a couple of questions about this, and my very simple answer on this is funeral costs are something that's going to occur once the care recipient is deceased and no longer living at home. So they are very clearly not allowed because they are not required to support the care recipient to live at home. Things like hearing aids, if the client can access government-funded hearing aids, you should not allow them to buy the items privately using their package funds. And that is even if they want a better quality one, and even if they're willing to pay the gap payment. The legislation is very clear that something that is government funded or could be government funded cannot be paid for out of the package funds. So next slide. I just wanted to touch then briefly on the rules about home modifications because this is being very scrutinised at the moment. So what I've set out here is really what the legislation says you can pay for in terms of home modifications and what it says you cannot pay for. And what you'll see is that what it says you can pay for is actually very narrow. So something like replacing tiling in the bathroom floor because it's cracked and a trip hazard would be okay because it's required to keep the home in a condition of functional safety. However, retiling the entire, or redoing the entire floor, definitely not allowed because that would fall into that home modifications or items that are not related to the care recipient's needs. So I think you need to be very careful with home modifications and really think about how you would justify that it falls within the things that are allowed. If you can't clearly show a very direct link to the care recipient's needs, I would be very cautious to approve that. So just on to the next and almost final slide. So I think for managing expenditure requests at the moment, you need to have a written policy in place for this because when matters are going to the Commission, they're asking to see evidence of how you've applied that. So you need to understand what is allowed, what is prohibited, and what is in that grey zone. And make sure not only your consumers understand it, but your care managers and coordinators. We so often hear that the care manager has promised something to the client. And the risk with this is if you decide, no, actually we can't pay for that, the risk is that you may actually still have to pay for it personally because from a consumer law perspective, the client might have gone and spent that money thinking that they would be able to recoup it from the package and you're now on the hook for that. So it's really important that your care coordinators and your staff know the rules really clearly. So that's why having a policy in place is really sensible as well. So if you are dealing with an item that's a bit in that grey zone, I would just think about whether you could get an independent assessment from, an assessment from an independent health practitioner that really clearly shows and supports you in why you're approving that request. But it doesn't end there, because ultimately it is your responsibility to make sure the item meets the person's care needs. And if it is an item that might benefit others in the home, also think about splitting the costs with them. So for example, you're getting the toilet fixed because it broke down, and there's another person or 3 other people living in the home. Think about whether you can actually share the cost with those other people, because that will benefit them as well as the consumer. Final slide, please. Okay, so in summary, there has been an increased focus on home care compliance, particularly on these sort of financial issues at the moment that we're seeing. So you do need to be careful with managing that transition of the clients across, if you still have some that haven't transitioned. Also, managing your fee increases, not only now, but moving forward into the future, and making sure your contract and your pricing schedules actually reflect how you want to increase fees in the future. You need to make sure you've got procedures in place for charging the income tested care fee, and actually can document those procedures if you have someone who doesn't pay that fee. And finally, do look at how you manage expenditure requests, because it is a really difficult issue for providers at the moment, and the consequences if you get it wrong are quite serious. So it is worth taking time to get that right at this point. That's all I wanted to say, so I'll hand over to Solomon.
Thanks, Anita, and thanks for those who are sending through questions. As Victor said, the Q&A function is along the bottom for those who want to engage in that, but also see the responses. And I'm assuming that Anita will start tapping away feverishly for those who have still got some our pending questions there. So as Anita touched on, home modifications is a sensitive issue in terms of the scope or the extent to which funding can be applied for those works. It's also an issue in terms of how you document those arrangements. And it obviously gives rise to distinct issues given the nature of those works. And I think we often see that a typical approach of here's our goods and services agreement, or here's a brokered services agreement to regulate those arrangements. And I think some more care and caution needs to be exercised in that regard. And as I've said in the slide there, I don't think that in all instances a template document is going to be a solution. And that's because of the unique nature of those works and the circumstances surrounding them. And as I've said in the slide, if you took the position of who is authorising those works in a typical building contract scenario, it would be the homeowner that would do that without question. Yet in a home care setting, it almost seems to be accepted in many instances that the AP can go in and somehow authorise those works, which creates a number of issues in terms of the responsibility that the AP takes on, but also then the interactions with the builder and the responsibilities that are taken on in that role. Another example would be at the other end of an engagement process. It would be very typical in a building setting to have a defect liability period, and then often some complaints about the nature or the character or the quality of those works. So if that contract is sitting with the AP, it will be the AP that then needs to enforce all of those issues or rights, which on its own would be problematic, but it would be most unpalatable if at that time the consumer is not even still your client, and you were left with a residual obligation or a bun fight of just trying to step into the breach of a home modifications or a works contract. So, we get that it's understood that there's concerns about reimbursement models in terms of the risks that presents, and I think some of the questions are coming through about that as well in terms of the monies that need to be expended and who's being engaged to do the works. But there are some other options with it. We've developed a template, what we call a tripartite agreement, which just is legal talk for 3 people entering into an agreement. And in this instance, the 3 people would be the consumer, the approved provider, and the builder. And it just simply sets out what the roles and responsibility of each of those parties are. So that the AP can still have a role in signing off on works and the process around the value of the works and the quotation processes, etc. The client, as the homeowner, clearly gets comfort around the scope of their works, and then they are engaging the builder, and it deals with some technical issues about who holds a building contractor and whether the builder is obliged to offer a building contract to the homeowner and so on. And it deals with those practical issues that I mentioned earlier about defect liabilities and so on would sit with the homeowner. And it also just simply allows the facilitation of payments, as in I'm holding the package funds, so long as the requirements under the Act are met in terms of the scope of works, etc. Then as the approved provider, I would sign off on those. So I think there's plenty to be gained by using that agreement. And as I said, we have a template available. And in addition to doing that, it's just very important that providers still just look through or consider their critical processes and issues. And as I mentioned earlier about the sign off on the scope of works, simple things like making sure that you have good processes around fixed sums so that you don't get hit with price variations from builders and the like. The next point that I've flagged is about Easy English and having better, I suppose, experiences or terms to communicate where you're going or what your expectations are. So we have developed an Easy English guide, which some of you who are participating in this webinar may have seen already. It accompanies our home care agreement, and it's really, I guess, an attempt to simplify things. It doesn't at this stage substitute the agreement, as in it sits side by side with our home care agreement, but we are working on an additional template that would be on a standalone basis. And as per the images that you can see, there's some text to give some context to some broader concepts in the agreement, but then also some images to try and land or ground people as to what themes or messaging is trying to be delivered. We've had some good feedback on it. Anita, you've done a lot of work on it. Thank you. And Bridget, who's behind the scenes, and others who are at RK has also done a lot of work on it. It's something that we are putting a lot of time into and we're trying to improve. So if people do have it or want it, contact us. If you've got it and you've got feedback, we'd really appreciate that because we think it's an important thing for the sector to be doing. And as I said, to really be engaging with those consumers and making sure that they understand what their agreements are, to try and head off some of those contentions of being misled as to what their agreement was, contentions of unconscionable conduct and the like, which can be detrimental to an approved provider. The last thing I wanted to touch on briefly before I hand over to Anthony was just around insurances and indemnities. And as I've said there, I don't think the sky is falling, although at day 41 for those of us who are still stuck inside, it feels like something's falling. Look, undoubtedly there is a sense of a change of appetite of insurers, and we've touched on that in other webinars that we've been involved in, and in particular one we did with ANSFAR. But I think the fundamentals are the same, are they not? There's always been exclusions under policies, and there's always been this issue about claims made policies versus claims occurring and so on. So don't lose sight of that. Focus in on it in terms of what you're expecting from your contractors, but also what insurance you're placing. Are there gaps in your cover, and are there gaps in your contractor's cover? I've put the question there, when did you last review your insurance policy in full? And maybe that was the last time you went to sleep at your desk. Look, it's not a particularly enjoyable task to sit through on an insurance policy, but it is helpful for you, again, at your own level, but also at your contractor's level, to really understand what's going on in the policy. Getting a certificate of currency alone will not really allow you to understand in any meaningful way what sits below that PI cover or public liability cover and so on. It is important to understand what the exclusions are, how that cover's being placed, and so on. The next thing I've just flagged is indemnities, which is often tied in with a concept of insurance, but is sort of different in one sense. And the reason it's often tied in is because of this concern that it runs counter to someone's insurance policy, but it also can potentially render the policy void. So in terms of running counter, the risk with indemnities, if you're giving them or if you're demanding them of others, is that someone will be incurring a liability that won't be met by their insurance policy. And this is often why people get themselves in a lather over it, that they don't want to give up rights in terms of a claims process or an exposure to damages in terms of mitigation concepts and the like. And therefore are concerned that if they give the indemnity, it won't be run back to back with their insurance, and therefore they'll be out of pocket for it. And the counter to that, I guess, is you can go and place your own cover. We're not worried about that. We just want to know that we're not exposed. So there's some competing tensions there. And I guess at some point, both parties need to be a bit commercially realistic about what can be achieved. The other significant concern is whether indemnities render policies void. And a typical instance that is cited is that it constitutes a waiver of a right of subrogation. So that is a legitimate concern. It's also a concern, I guess, that if you've got indemnities in an agreement and it renders an insurance policy void, were you better off relying on the insurance, or are you better off relying on an indemnity? So you need to consider that and be very careful, I guess, with the wording that you put in your contracts or your brokered services arrangements. So that's it from me. A little bit over the halfway point, and I'll flick on to Anthony.
Thank you, Solomon. So, look, when we sent the invitation out, what I thought I was going to be talking about were the changes to the SCADS award, some questions we've been getting around the Portable Long Service Leave Benefits Scheme, and just generally talking about health and safety for home care in the COVID context. Obviously, the last week has been a big week in workplace law, so I'm now also going to be talking very briefly about the new reporting obligations and the worker permit scheme, and I'm going to adjust my timing a little bit to reflect what's probably a bit more important. So changes to the SCADS award. I'm going to deal with this very, very quickly. The short of it is, as of the 1st of July 2020, the casual rates for weekends and public holidays have increased. This is to basically add the casual loading onto the penalty that would otherwise have been there for an ordinary worker working Saturdays, Sundays and public holidays. As I said, there's a bit more to say about this, but it's kind of yesterday's news at the moment. So let's move off that and have a look at the Portable Long Service Leave Scheme. The main thing I wanted to talk about here is that there is some ongoing uncertainty as to whether the scheme applies to home care. That uncertainty is completely understandable. The authority says quite clearly that home care workers are covered, but when asked, will not provide a justification or any reasoning behind that, and will suggest that you maybe go and get your own legal advice. The Act says that the Portable Long Service Scheme applies to home care support services for people with disability or other persons who are vulnerable, disadvantaged during crisis, which suggests home care, or at least some home care, is in. The regulations specifically exclude aged care. And the guidance note, also produced by the authority, says that home care support services provided in private residence that are not health or aged care work are not, go back again. Home care support services that are not aged care are included in the scheme. So what that suggests to us is that providers who predominantly provide aged care services in the home are not covered by the Portable Long Service Leave Scheme. Providers who do a bit of a mixed bag and include disability and other services might be covered depending on the extent to which they are performing those other services and the extent to which they're performing aged care. So yeah, look, that's, I suppose, the last thing I'd say about that is that the government has acknowledged in November last year that they made a terrible mess of the regulations. They didn't use those words, but let's call it what it is. And there is going to be a new set of regulations in theory coming out in November. All of the consultation on those regulations has been pushed back for some reason. Everyone seems to be busy with something else at the moment. So no clear timeline on when the new regulations will be released, but there is a possibility at least that people are going to, that the government is going to try to bring home care more squarely within the scope of the Portable Long Service Leave Scheme. And just a thing I should point out, some of the material that I'm talking about today is applicable across Australia. Some of the material I'm talking about today is responding to particular things which are occurring in Victoria at the moment. I appreciate that some of the people here are not, or here virtually at least, are not in Victoria or are not in the restricted areas of Victoria. but I just don't feel I could not talk about some of the state-based issues given what's going on. So next up on that list is the permitted worker permit scheme. This is a horrendously confusing set of rules. It's contained across about 12 documents. I did try to do a diagram explaining how they interact, but it ended up looking like a Jackson Pollock, so I just left it. Essentially, what it does is this. A person can leave home to work if it's not reasonably practicable for them to work from home. They can't leave home to attend a work premises unless they have a permit or an exemption applies to them. And a work premises means the premises of an employer, which includes a work vehicle. This leads to a few questions for home care. Obviously, a home care worker can't perform work from their own home, so it's definitely reasonably practicable for them to be, it's not reasonably practicable for them to be working from home. But are they actually attending work premises of an employer? I don't think it could possibly be interpreted in that way. So quite clearly, they're not attending work premises with a capital W and a capital P for the purpose of the scheme. Does a person who leaves home to work but doesn't actually attend work premises need a permit? If you look at the words of the health directions, the answer to that question looks like it's actually probably a no, and that would suggest that home care workers don't need permits. That seems really unlikely to me to be what was to be the intention of the government, because otherwise people could simply leave home at any time and when questioned say, oh, I'm a home care worker. So while that's what the regulations, sorry, not regulations, that's what the directions say, that's the conclusion they lead to, I don't think that's a conclusion we should be accepting. And given that the fine for getting it wrong is just short of $100,000, I'd be inclined to go on the assumption that they probably just weren't thinking about home care when they drafted this, and they probably would have meant for home care to be covered if anyone had raised it with them. So I would go on the basis that the employees should have permits. There is an exemption that applies to health workers who are carrying a photo ID from their employer that identifies their place of work. Is a home care worker a health worker? Logic would suggest yes, the department suggests no. So I'd call that another question mark area, and I would act on the basis that they're not, and that carrying photo ID from their employer is probably not going to cut it. I'd love to hear if someone's spoken to the department and got a different perspective, but that's the information we've been able to obtain so far. The other question I suppose which this arises is when we're saying photo ID from the employer which identifies the place of work, would that have to identify the person's home, or could it be the employer's place of business? I think from a practical perspective, it would need to be the employer's place of business. But as I said, I'm just not confident that this exemption can apply to to home care workers. Next slide, please. So assuming home care workers are actually covered by the scheme, can a home care provider actually issue a permit? A permit can only be issued by a permitted employer conducting a permitted service. Those services include aged care and community care services. A permitted employer is an organisation operating a permitted work premises, and that is defined to include aged care and community services and disability services, community-based health services, etc. Broadly speaking, there's again a whole lot of confusion coming from the fact that most of this has been published in a rush over the last 48 hours. There's a lot of internal inconsistencies across the documents, but we think this is intended to cover home care and that a home care provider can issue a permit, and as such, we say they probably should be. Sorry, I'm told by Chris Hampton from AXA that they have asked DHHS if a worker carrying a permit also carries a printout of their calendar or roster, and they're still awaiting a response from the department on that. Thank you, Chris. So yes, look, I'd say this is intended to cover home care, and as such, you should be issuing permits. You should probably already have issued the permits, and you should be keeping a record of all permits issued. As to the permit itself, turning to the next slide, please. Helpfully, completing this document with false or misleading information can attract a penalty of $20,000 for an individual and up to just shy of $100,000 for a company. So it's important to get this right. And again, coming back to the fact that this was really not designed with home care in mind, the employer has to attest that the workplace is compliant with public health directions. Well, the workplace is something completely out of your control. It's the client's house. The employer needs to attest that all reasonable steps have been taken to ensure a safe working environment. Again, elements of that out of your control, and that there needs to be a COVID-safe plan in place. Now, the COVID-safe plan, we don't need to worry about because it only applies to a workplace with 5 or more workers, and that's not going to be a home care scenario. In terms of the ensuring that the workplace is compliant and safe, that's something which really you don't know until the worker gets there each day. So all you can really do there is ensure that the employees are well and truly across safety and infection control measures. They know what to do. They know what PPE they should be wearing. They're capable of conducting site audits, at least at a high level, to see whether the site looks safe. They should probably be asking their clients, if their clients are capable of responding, what steps those clients are taking to ensure hygiene, etc. The employees on signing the permit, they need to state that they understand the language around diagnosed persons, close contacts, and what to do if they are diagnosed or one of their close contacts is diagnosed. So again, you need to be ensuring that your staff are across all of that, what they need to be doing, what the language means, that sort of thing. If you don't have confidence that a site, a client's house is a safe place for your staff, then you would really need to be considering pulling staff from the sites. Just on a related note, a question which came in earlier, obviously we know that the staff, home care staff, need to wear masks. What about the home care clients? I don't believe there's any legal requirement that the home care recipient wears a mask. At the same time, I think you should definitely be asking them to put masks on. Certainly if they have been experiencing any symptoms which could be attributable to the virus, but just generally, we should be asking them to wear masks as a part of just cooperating with our health procedures. So this rather flows into the next topic, which is a bit more inclusive of people who don't live in Coronaville. And that's just generally safety obligations in home care. What coronavirus means in terms of safety obligations is really the same obligations, just a new set of risks. So you still need to be providing and resourcing for safe systems of work. You need to have good, up-to-date and continually updated infection control practices as we learn more about what works and what doesn't. You need to be ensuring hygiene, social distancing where at all possible, and the availability of gloves and masks in a range of sizes. There are a number of, well, in Victoria at least, where the masks are a requirement, there are exceptions around people who can't wear masks because of medical conditions, because of disabilities or past trauma, etc. So there are a number of excuses or circumstances in which staff are not required to wear masks. Beyond that, though, broadly speaking, we would be recommending that home care workers wear their PPE. You need to be ensuring that you've got training, instruction and supervision in place so that they understand what they need to be doing. They understand how to use the personal protective equipment, and finally, trying to make sure that they are actually using it. Moving on to the next slide. Pardon me, more of the same. It's reporting obligations is another really important part of this, and that is requiring staff to report back to you regarding clients with cold or flu symptoms, requesting possibly that clients notify you in advance if they're experiencing cold or flu symptoms. I put a question mark next to that because based on the experience of some of our clients, if staff know that their client is experiencing cold and flu symptoms, they'll refuse to attend. So that's, I guess it's one of those things where you want to know, but at the same time, the knowledge might cause you more trouble. Staff should also be reporting back to you regarding clients who refuse to comply with infection control procedures or any directions around infection control. And you should be trying to consult with your staff to the extent that's possible, again, to make sure that they are using PPE, that they understand how to use it, unless, of course, they've got a legitimate excuse, and following up on any issues that are reported. Oh, sorry, another issue that is another exemption in relation to masks is if the client is hearing impaired or dependent on lip reading, then obviously the support workers should not be required to wear masks when communicating with them. The other thing which I was going to talk about briefly, so yes, thanks Bridget. Again, this is a Victorian thing. I'm not going to talk about it in great length because I don't think it applies to home care. New notification obligations were inserted into the, new regulations for occupational health and safety that sit alongside the rest of the regulations and expand the duties under Section 38 of the OHS Act. And essentially what they mean is if a worker is diagnosed with COVID-19 and they attended the workplace in the 14 days before that diagnosis or before the onset of symptoms, you need to report it to WorkSafe. That being said, it only applies to the workplace which is under the employer's management or control. I think that's unlikely to be the case for home care, but these rules are, 6 days old now? So there's no case law yet, and we don't have any indication from WorkSafe as to what they're thinking about this. Final slide, please. I think the other thing to bear in mind, and this is probably the slide that I was going to be running with 2 weeks ago, is don't forget the old risks. Obviously, COVID's a big focus in Victoria, but the rest of the issues still apply. We're seeing increased enforcement activity from WorkSafe, or at least we used to, a couple of months ago, increased activity from WorkSafe in relation to occupational violence in home care. We had I think improvement notices issued to one of our clients in relation to a worker who was stabbed by their client, and WorkSafe was very thoroughly going over the behaviour management plan and all of the other notifications to see whether there was any indication that this might have happened. And they were taking a pretty, they were really operating on the basis that hindsight is good enough. So yeah, you need to be very clearly establishing behavioural expectations with clients, communicating and following up whatever incidents you've got, documenting any incidents of inappropriate behaviour and documenting your response so that you are able to produce to WorkSafe, if the situation escalates, evidence that you had systems in place. And training for workers on dealing with occupational violence, de-escalation to try to reduce the likelihood of things going wrong, avoidance, how to obtain assistance, and obviously training in relation to reporting. Workers should also be conducting site assessments more generally, and again, coming back to what we were talking about in relation to COVID, but not just in relation to cleanliness and hygiene, site assessments in terms of making sure that the large dogs are not in the room, or various other safety risks that might arise are being managed. And finally, travel risks around fatigue management, and the other thing which you can be doing to minimise travel risks is trying to schedule things so as to ensure that there is adequate time to travel safely between one appointment and another. So yeah, covered a fair bit in a fair rush. I think we're now heading back to questions.
Yep, thanks, Anthony, for that. And I'm mindful that we are at 3 p.m. and the schedule for the webinar was 2 till 3, but we've agreed to amongst ourselves, and hopefully you'll stay on board for a little bit of extra time. I can see we've still got a number of attendees for some of the questions and answers. So please, we've managed to get through a significant number of questions that have been posed, and there are some more that we need to get through, and I'll direct those to our panellists. Anthony, I'm not sure whether you noted comment from Deb that they have issued permits to their home care workers who cross between stage 3 and 4 borders, and so far they've been accepted without any issues. We have one question, I think, that may be relevant, Anthony, to you, which is whether home care workers in New South Wales should be wearing masks even if there are no symptoms or COVID. I don't know whether you want to address that or not.
I suspect this is one of those questions where my answer will either be right or drastically wrong in hindsight. But look, given the rate at which things changed in Victoria, I probably would be recommending that they do wear masks, even if there are no symptoms at that point. I'd say at this stage, you know, considering what's reasonably practicable, I'd say it's pretty practicable for a person to wear a mask. It's not a huge expense, and the risks of things getting out of control are pretty significant, as we've demonstrated down here. So I'd be inclined to suggest that they do.
Okay. Another question that may fall within your area, Anthony, is whether you think it's reasonable for a salesperson to access a permit to be able to go out and sign up a new customer. For example, does supporting a home care permit holder to get services qualify as a permitted worker?
That's a really good question. There is a provision around ancillary services that are connected to administrative services, system support, etc., as they relate to the above, to health and community services, but I'd want to look into that. I'm not 100% sure about the answer to that question.
Thanks, Anthony. It is one that, like so many of these matters, when you start looking around the edges, it becomes very challenging. But I guess the rule of thumb is that if you really don't need to go out, don't do it. Now, another question for you, Anthony, is who is responsible for the provision of masks to brokered services? And perhaps, Anita, you may also have a view in relation to this, but the question is, who's responsible for the provision of masks to brokered services?
So I suppose, depending on the brokerage arrangement and the model, if you've got an interposed contractor and they're providing the labour, then I would have thought they would be the ones who are providing the masks to their staff.
I'd agree with that, Anthony. I think, and it'll depend on the terms of your contract, but under our service agreements, for example, the contractor is responsible for workplace safety. So you do need to look at what your contract says, but they're the employer in that scenario. And I would have thought that, yeah, it should be their responsibility primarily, but it will depend on what you've negotiated in terms of your service agreement with them.
Thank you. I note that Jane has posted a comment dealing with New South Wales, where certain specified areas have been identified where home care staff must wear a surgical mask while providing services. So thank you for that, Jane. I should also just let attendees know we've had a number of requests for the provision of our Easy English guide and templates. If you shoot through your details on the Q&A or the chat function, we'll pick that up and provide to you information about the pricing and perhaps samples so that you can have a look at that. If it is something of interest, you can get back to us in terms of the purchase of those. Okay, so that one's been dealt with. So Karen's asked the question. So we're down to two remaining questions. So some providers who broker to us are demanding that we provide our staff with face shields and full gowns with no reimbursement, even though this is not a government requirement. How do we handle that? Anita, how would you handle that?
Sorry, just having issues with my mouse. Look, the same sort of principle. It will depend on your agreement with them, but I'm not really sure on what basis they could demand that, unless Solomon, Anthony, either of you have a view on that.
I guess I would comment that in many instances, complying with the directions is couched in a reasonableness kind of language. So, in that instance, I guess you would have to question, is that requirement reasonable or even necessary in one sense?
Yeah, I think that certainly the language that has been used has been about applying common sense. That seems to be a standard. Of course, whose common sense we're talking about is always one up for debate, but I think it is a question that can be answered in the way in which Anita and Solomon have identified, and Anthony as well. So thank you for that question. Karen, an anonymous attendee has asked who is responsible to issue a permitted work permit to contractors of HCPP providers. Anthony?
So a person who's an independent contractor, they get to issue themselves with a permitted work permit, just for a bit of hilarity. But that's very clearly stated in the directions that a person can issue themselves if they're with the permit, if they're an independent contractor, a sole trader, or a subcontractor. If what you're talking about is the staff of your contractors, then I think we've sort of answered that question a couple of questions back. It should be the contractor issuing permits to their staff.
Okay, thank you. Just had a couple of additional comments in relation to that some clients are seeing the full white suit arrangement on TV and then expecting staff to will wear that too, and also Karen followed up noting that the requirement was to protect their clients, not their staff. So we have expectations being raised by seeing the full hazmat outfit in some circumstances. Okay, so I think that actually at the moment sees us with still a number of people on the line, but all of the questions would look like they have been answered. So what I might do is just remind those who are still participating in the webinar, before we move to the key takeaways, if I could remind everyone to fill in the feedback survey towards the end of this, or if you're about to leave, and certainly using that QR code that you see there, and if you get the presentation slide, perhaps use that. So what I might do is actually ask our panellists to perhaps wrap up with their key takeaways from today, and I leave it to Anita, Solomon and Anthony to work out the order in which they summarise today.
I'm happy to go first. I suppose just looking at all of those things I spoke about in terms of pricing, make sure you get your pricing schedule right, particularly if you are going through a renegotiation process with clients at the moment, because perhaps you found your pricing from last year didn't quite work. Now is the time to get it right. So if you need to as well, get advice from consultants. I know there are pricing tools out there from various consultants that would enable, can assist you with getting that right. I think Laser have a pricing tool that you can help you get that right as well. And it's better to get it right now rather than have to go through a renegotiation every year. So again, looking at your fee increase mechanisms, because otherwise you're going to be in this process of having to renegotiate every year, and clients will effectively have that power every year to say no, not unless you do X. So look at it all now, get it right once, and hopefully that stops you having to go through it.
Anita. Solomon?
Yeah, just as I flagged there, just take some time to consider your procurement models. We've got some templates available, and they're really there to make life easier for everyone. and to cover off on risk. It's very easy, I guess, to fall into a habit of issuing out your standard agreements. It's not a essentially easy task to revisit things, but once the agreements are in place, I think most of your models in terms of your processes should be pretty sound without too much rejigging. So just give it some thought.
Thank you. And Anthony, would you like to perhaps finish up with the takeaway? And I think there are a couple of questions there that may fall within yours and Abby's area, but I'll leave it for you to respond.
Okay, sure. Key takeaways. Well, as far as I'm aware, the law hasn't changed in the last hour, which is great. The main things I would be saying is just make sure that your staff are really across infection control protocols, and that you're continuing to provide training and information around that in whatever way you can. That's probably the most important element of the piece from my perspective. As for the worker permit scheme, there probably will be more clarity on that as time passes and as the government gets more of an opportunity to refine it. So I guess what I'd suggest there is just keep your ear to the ground, and we'll presumably be talking more about what we think it means as more information becomes available.
Thanks, Anthony. Well, I think with that we might wrap up. Can I thank Anthony, Solomon, Anita, and Abby behind the scenes for the presentation today. It's been really interesting and a lot of great information, and the feedback you're suggesting has been helpful to the webinar participants as well. I'd like to, as always, thank our BD team who work hard behind the scenes to bring these webinars together. Thank you to the attendees, for all of you out there who have joined us today. As I said, please send through your feedback. A number of you have sent through information to get a copy of our sample guide and templates, and any other specific questions that you've got, please send them through. And in these strange and difficult times, Russell Kennedy certainly wishes that all of our clients and their staff stay safe and stay well while we get through this difficult and challenging time. And we look forward to seeing you all at the other end. And finally, don't be confused by my background. I am at home. I'm not at work. I don't need to be at work. I don't intend to be at work, and probably at this rate won't be at work for a long time, save for what I'm doing at home. Anyway, thank you all for joining us. Stay safe and stay well. Goodbye.